Well, we're in our last session now. So thanks everyone for hanging around. This is going to be a very special panel here with some very special people, especially very special to me. So let me just introduce a brief introduction of the panelists, because if I was to give you their full bios, we'd have to hope it would be a leap year because of all the things that they've done in their really illustrious career. So on my far left, Harvey Rishikoff is here. He's the chair of the American Bar Association Standing Committee on Law and National Security. He's the former convening authority of military commissions. He's a professor at Temple Law School. I went to Roger Williams, so I'm very proud that he is the former dean of the Roger Williams Law School. Not that they had a law school when I went there. And a dear friend, he's on the advisory, on the executive board of the Center for Ethics and the Rule of Law, where I recently completed an assignment as the interim executive director, and I work very closely with Harvey on that, and on the Gitmo working group report that we just released a little while ago. In the middle, Alyssa Massimino, a dear friend, visiting professor of law and executive director of the Human Rights Institute at Georgetown Law Center, a senior fellow center of the American Progress, and former president and CEO of Human Rights First. And actually, I am probably standing here today talking to you because of Alyssa Massimino, because Human Rights First came to me years ago when a book called Hard Measures was written by a former CIA CTC director. And Alyssa said, we need your voice. We've heard you speak privately about these issues, and we need you to speak publicly about some of the things that you've encountered. And so Alyssa is the one who drew me out of the shadows and Human Rights First, and working a number of programs within. So thank you and welcome, Alyssa. At my left, my dear friend, one of my heroes, Alberto Mora. Alberto is the former the past associate executive director for global programs and the director of the Rule of Law Initiative of the American Bar Association. He is the former general counsel of the Department of the Navy. And I had the pleasure of helping Alberto ease him into the private sector from the Department of Navy. Instead of being the Navy general counsel, I helped him get a job at Walmart. But the best one, yeah, that's right. And I got him a nice blue vest for that. But truly a national hero for some of the stances that he had taken for our country. Really, I won't go into much more, but I just want to welcome and ask you all to join me in welcoming our panel. And Alberto, will you please talk first?
Happy to. Thank you, Mark, for the introduction. And let me also say that Harvey and Elisa are also dear friends and colleagues whom I respect greatly. In fact, Elisa is also responsible for me kind of edging my way to human rights in a more formal way as well, because she also reached out to me when I was at the Pentagon, and then we've maintained a relationship ever since. We're here to talk about, oops, thank you. Interrogation, but we're talking about interrogation because of the prevalence or the incidence of cruelty and even torture in certain interrogation regimes. So I thought I would analogize this issue, which is mainly focused on domestic and police force aspects of interrogation, with the experience that we in some way all shared. All of us shared at the Pentagon in dealing with the Bush administration's adoption of torture as a weapon of war during the War on Terror back in 2001, 2002, and for a few years after that. The first thing I want to start with is the comment that John McCain often made about torture and cruelty, which is that it's not about them being the enemy, but it's about us. And I want to start my presentation with that comment because it's all too true. That's the right way to frame it. The decision to use cruelty, whether it be in fighting foreign enemies or in policing domestically, helps define the country we are in an important way. I find myself astonished that I'm still involved on the issue of torture and cruelty 20 years after my first involvement. And part of the reason is because, first of all, it's not solved. We haven't fixed it yet, either internationally or domestically, but also because this issue is so critical to a lot of first principle issues in our government. The issue of cruelty touches on values, norms, laws, culture, practice, and foreign policy, and not actually also national security strategy. All these issues are directly implicated when we talk about the issue of torture. And my involvement in this issue came as a result of NCIS, and Mark played an important role in this. Mark and his then boss, David Brandt, came to me one day and said, look, we're hearing rumors that detainees are being abused in Guantanamo. Do you want to know more about it? Well, I did, and that's led to a 20-year involvement almost continuously with this issue. The point is that whether we commit torture or not will define the society that we choose to live in, and the decision to consciously apply cruelty or to tolerate cruelty will define precisely the kind of society we are. When I got into the issue of enhanced interrogation in the Department of Defense, there were a number of arguments that were raised to justify the decision. The principal arguments were that it was, first of all, legal. Second of all, that it was safe. Third of all, that it was effective. And fourth, that it was necessary. These were the arguments at the whole that in whole or in part were consistently raised against it. Now, it's none of the above. Enhanced interrogation and torture is neither legal nor safe nor effective nor necessary, nor was it on 9/12 and the years after. And I think the history and the literature that's been amassed and conclusively proves that. But a lot of people aren't convinced yet. Not by a long shot. A lot of people don't understand what happened, and a lot of people still believe that, in fact, what we did in adopting enhanced interrogation was all of these four elements. When I first got involved in the issue, I had no prior involvement or experience at all with interrogation. I was a civil litigator in private practice before I came to the Pentagon. Had not had even the criminal law experience that a lot of lawyers would have, in which interrogation is an element in a defense of an accused client. And my approach to it within the Pentagon was to first of all say it's categorically illegal. So I was deploying the illegality argument within the Pentagon, but it gained no traction at all, to my astonishment. It was not sufficient to convince those who were supporting this within the Pentagon. First, because I didn't realize, none of us realized, well, at least I didn't realize that anybody outside the Pentagon was involved in this issue. I thought it was a homegrown issue, and in fact, it was homegrown in Guantanamo, nothing beyond that. And also the policy argument, the notion that our foreign allies would not tolerate in America that practice torture within the domain. So those arguments were not having the effect. And at one point, I turned to the NCIS delegates to the so-called DoD working group on enhanced interrogation. The working group was established by Secretary Rumsfeld to revisit the policy and legal arguments associated with this. And I told the group, look, we're getting nowhere with simply saying no to what the secretary is proposing. We have to come up with an alternative argument. We have to say no, but this, meaning you can't find something with nothing. You have to propose an alternative that would achieve the objectives of enhanced interrogation, but do so in a more intelligent ways. And I turned to my NCIS buddies and I said, is there any literature on this? And they were amazed I had asked the question, because their response was, of course there is. You know, the history of interrogation demonstrates that the use of cruelty is counterproductive in any number of ways. And I was, like a light bulb went off, but then I asked them to prepare something over the weekend. They prepared a 40-page memorandum, and then they prepared it a couple of weeks later, they prepared a 200-page memorandum, which was then sent into the process to no effect. But the reality is that the utility or the counterproductiveness of the use of cruelty is a necessary argument in combating those who tend to believe that cruelty may be effective or is effective in certain situations, which is as true internationally as it is domestically. Now, on the domestic context, the reason why this argument is so terribly important is because many Americans, and this is true of probably all countries, are of the belief that situationally, cruelty may have to be resorted to in order to prevent a greater harm. Well, this is this is a false understanding of the use or counterproductiveness of the use of cruelty in interrogations, which is what Mark and Juan and others who've been involved in the Mendes Principles Project is so terribly important. And this has not been learned. Years after we had abandoned enhanced interrogation formally, I had occasion to lecture both the Rhodes Scholar candidates at the Naval Academy and the Rhodes Scholar candidates at the West Point. And just to get my bearings at the start of the class, I asked the students to raise their hand if they believe that torture should be categorically prohibited under all circumstances. Only 2 or 3 out of the 40 or 50 students in the class, in both classes, raised their hands saying, yeah, I believe that it should be categorically prohibited. The rest of the students believed that the use of cruelty was a situational question, that it really depended on the level of the threat. If the threat was large enough, then torture should be contemplated as a potential tool. And I think most of American society believes that as well. So the same is true on the police setting, where enhanced interrogation was in the context of foreign terrorists attacking the United States and possibly attacking us again. The calculus domestically is exactly the same, although now in the context of criminals that infecting society. There are many Americans who believe that drug dealers, for example, or other mass murderers and others should be in fact tortured if that could save the problem or save a kidnapped victim or something similar. So the issue has the same resonance, has the same framework in the domestic criminal context as it does in the international terrorism context. The students at West Point and the students at the Naval Academy did not understand the technical aspects that this project has shown out, that in fact, the use of non-cruelty, relationship-based interrogation techniques is actually more effective to combat crime as it is foreign terrorism. And consequently, it dovetails with the legal and ethical arguments that are, to my mind, actually are dispositive of this issue in helping an individual work through the issue as to whether or not interrogation should contemplate an element of cruelty. At the end of the day, we don't want a crueler society. We don't want a nation that is crueler. We don't want a world that is crueler. And this issue here, how we treat captives, either in the international context, military context, or in the police context, is foundational to answering that question. I'll stop there.
Thank you, Alberto. Alyssa?
Thanks. So it's really great to be with you, and I gather this is the end of a really long day for you all talking about torture and interrogation. So I congratulate you for being here. It's a beautiful day outside, but you probably don't know that. So I'm here to provide a perspective as a career human rights lawyer and an advocate. You heard that our histories of all of us are intertwined around this issue over the last 20 plus years now. But I started working on the issue of torture in police interrogations very early in my career, because but I spent most of my time before the 9/11 attacks working on the human rights performance of governments other than the United States. So I was very focused on the use of torture in Turkey, because it was rampant. It was the primary, at that time, methodology of the police in a confession-based system, where all the incentives were not necessarily to find the bad guys, but to close cases and just to get somebody to confess to whatever. And actually, back then in the early 90s, we met in Turkey. We talked to prosecutors and police officers and judges about how the system worked and how to deconstruct those incentives. And Professor Juan Mendez was there at the beginning as an advisor. But back then, I really was never thinking that we would be dealing with those issues in the United States, even though, of course, that there's a long history of that in our own country here. But I was much more focused on what was happening internationally. And then a lot of things shifted after 9/11. And in fact, I had to learn about how the CIA operated, how the Defense Department operated, something I hadn't focused on very much. And to be honest, when the revelation started coming out about the torture of suspects in US custody in the media with unnamed sources, I wasn't sure I believed it, even though you might think that as a human rights activist, I'm primed to, doubt the, fidelity of state or government to human rights principles. I actually thought it was far-fetched because I knew that the law was clear, and I knew that, particularly in the military, about the training. I grew up in a military family, and so I was skeptical. And I remember we went to the Pentagon to have a meeting, a bunch of human rights organizations, to say, this is a real problem, and you better make sure that this actually isn't happening. We don't think it is, but we brought stacks of foreign media reports about how this was playing abroad and how it would undermine the war effort. And we were very concerned about it. So we went in kind of as patriotic Americans to talk to people at the Pentagon about how we saw this playing out globally and how important it was to get for the government, for the administration to get in front of that and disavow it or send a message that, hey, this is not going to be tolerated. And instead, we got a barrage back from the Pentagon General Counsel's office in that meeting about how dare we question the motives and the actions of U.S. military fighting a war. And that's when I knew that there was something going on. It was a very aggressive response from our government. And it was in one of those, and then I spent a lot more time wandering around the Pentagon back when, you could wander around in meetings. And that's where I met Alberto. In one of those meetings, I remember, I don't know if you remember this, but we had a meeting talking, I think it was really about Guantanamo. And you followed me out afterwards and said, keep pushing, no government is a monolith, and there are people inside trying to, do the right thing. So that's when we started to, human rights groups, of course, it's, dog bites man. Everybody was outraged. We were campaigning and Amnesty, and everybody were, saying this is horrible and you have to stop it. And it's illegal, it's immoral, but we didn't know whether it was effective. And it's quite a radical thing for a human rights organization to even ask that question, because what do we care? We're still going to be against it, right? But we acknowledge that the country, still gripped by fear, was, really being told constantly every day by the Vice President's office and the White House that this was exactly the opposite of what you said, Alberta, that it was necessary, that it was effective, that it was saving American lives. And in that environment, I'm looking out, some of you will remember that environment and some of you will not remember that environment, judging by your ages, but it was very, very powerful. And so we decided to ask the question, how does this actually work? We're human rights lawyers. We know the law, international law, and we know about violations and all that, but we didn't know anything about interrogation, what really works. So we decided to approach it with humility and great care in convening people who did know about it, who had experience as interrogators, interviewers, to ask the question, how does this work? And we discovered, to our great relief, in private, that people with the most expertise about this issue were even more concerned about it than we were. And mostly not just about its immorality and illegality, but really in the context of a war on terrorism, that it would cost us vital intelligence that would save American lives, not that it was getting us into that kind of intelligence. And that's where we started to build the relationship and a platform for people who knew a lot more about interrogation than we did to speak to the American people about it. Because we also, we also were up against the most powerful force in our country, which I think is popular culture. I don't know, did you show the video earlier today?
No, I didn't. No.
Well, you all have to watch this video that Mark did for Vanity Fair.
Vanity Fair.
Also back during that time period, the most popular show on television was a show called 24, which was a high intensity, show with the clock, literally the ticking time bomb, and the clock was ticking. And it was a, half hour or an hour long advertisement for torture watched by 15 million Americans every week, where, the good guys were the ones using torture. It always worked and saved the day. And that was the most popular show in Congress at the time. And some members of Congress had walk-on roles sometimes on that show. Everybody loved that show, except like me. But I watched it because I, wanted to understand what we were up against. Anyway, the video that you should watch, if you Google Mark Fallon Vanity Fair, it's on YouTube, is a brilliant deconstruction of the way torture is depicted or interrogation is depicted on television and in movies. This is what most people still think works. And that's why I'm really so excited about the Mendez principles. I'm sure you've heard a lot about them today, but not all, this is, we're now entering a stage where we need to get a lot more practical about. We all know that having something be the law is like sort of important, but not the end by any stretch of the conversation, that this really has to be embedded in our culture, in our practice, our training, and in the public eye, because that's where, when we meet moral crisis again, which we sadly, I'm sure will at some point, we need to have, the internal moral compass and the knowledge base that I think is so, now we are so better off now, even with the very few hands being raised at the service academies. We're in a much better place now because we know more about what works and we have more tools at our disposal, but we still have to embed this in, we invest in it and be training people and having, it's kind of boring to watch a show about real interrogation, to be honest. And that was, we went to Hollywood and talked to the writers and brought, the dean at West Point with us to talk to the writers of these shows that were depicting torture. And, and told them, hey, a lot of people are actually watching these shows and they think that's what works. And they think that's what they should do if they want to be instrumental in saving American lives or solving crime. So you need to do something about that. And you're like, oh, we were just coming up with revenge fantasy ideas for our shows that were going to be popular. And in fact, it was quite popular. But that is part of what we're up against. So I think, from my perspective, as a human rights lawyer and advocate, the experience of this period of acceptance of torture in the United States as official policy really had shifted my whole approach on human rights strategy, and that was to meet people where they are and to listen to the experts and spend less time pontificating and more time figuring out how do we move from where we are to where we want to be, and how can we work together to get there. That's not there.
Thank you.
Sure.
Harvey?
Thank you. First, Mark, thank you for the generous introduction. I just have gotten fired a lot in my career, both in international and domestic jobs. And I'll do the typical declaration. I'm here in my personal capacity, not in institutions I represent, all of my government affiliations. I'm here in my own personal role. So let's, I approach the issue in a variety of ways. The first is the actual Eighth Amendment. So our Eighth Amendment constitutionally is quite clear that it says excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. So that's sort of the black letter law. And as part of my career, I was legal counsel at the FBI, where Fallon has a similar background. And from the Bureau's perspective, the issue is driven by domestic considerations on domestic law. And it's driven by the fact that evidence we know induced with the violation of some form of violence or torture will not be admissible in court. So really what drives the institution is the inducing of information that must be admissible. So I call that institutional ethics. We don't really, and there are many institutions, but it's unclear how you actually operationalize and make it clear in the culture as an ethic for the institution, because all the agent has to be told when brought before the prosecutor, and then ultimately, as we say, the seventh floor of the Bureau, you did this, there's not the right chain of custody, this evidence is inadmissible. You have failed in your function of what you're supposed to be doing as an investigator. So that became drummed home in the Bureau's understanding about what's going on. So I know you spent all day talking about the domestic side, and then there's an international side. So it's almost cool and unusual to keep you here because I'm the last speaker on the panel. So I'll be brief and have more of you guys for Q&A. But then the other question is institutionally, for instance, I was the Dean of Law of the National War College. We have not signed Protocol 1 in the Geneva Conventions. And what's interesting about that is in Protocol 1, we hold the commanders liable for violations of the law of armed conflict that they knew or should have known. It's a huge distinction, knew or should have known. And why that's significant is, but we talked about the age. Now we're going to reveal my age. So many of you, my lie was a big issue for me in the Vietnam War. And Carrie is prosecuted. And the question though is how far up on the chain are you going to go for what took place in that village in Vietnam? And the decision made at that time, which became critical for liability questions for general officers, was that you had to have what we call the classic criminal algorithm. You needed a guilty mind and a guilty hand. You had to knowingly participate in the guilty act, which stopped the issue from going for any prosecution higher in the chain of command that he was part of. Think about that. That created a different institutional ethic. Now, bear in mind, at the same time, when we went after the Japanese admiral and prosecuted him and executed him for activities that took place in island chains in World War II, at that time for the Tokyo trials, we held the principle of knew or should have known as the commander. That is not the current ethical standard that we have, as Alberto will tell you inside our law. So first is, what's the institutional ethics? How are you inducing? How are you prosecuting them? How are you enforcing them? And what does that mean down the road institutionally? The second issue that this raises, the issue of Guantanamo, which we don't have in the domestic side, is the concept of covert action. So the whole policing of covert action, the whole accountability of covert action that we require allegedly under HPSI or SISI, the House Intelligence and the Senate Intelligence, at what point in time should the appropriate reviewers of Title 50 covert action be informed of what is taking place? The famous legal phrase that is now statutorily is in a timely manner. And Congress has had many opportunities to reform that language. It could be immediate, could be within 24 hours. It's maintained timely manner. And one of the arguments is it's unclear because when you're actually informed of something, you actually may be required to do something, which, though I love Congress, is not often what they're known for, is responding with alacrity to issues that are presented to them. Again, it's an institutional decision that we made, which has huge political and policy and legal overtones. The third point I want to make is, why do we keep on having torture? So torture is as old as the Bible, bless you. Literally as old as the Bible. And as Ellen said, we've done studies about how do you induce information, appropriate induction. You get a lot of false positives when you use coercion. But when you use coercion, you also do occasionally get positive positives. And that, as a result, fuels this issue of the, as you would call it, Jack Bauer approach to its continuity across time and across cultures. You have to have an explanation for across time and across cultures. So the counter argument, of course, is that it doesn't, or you get false positives. But that debate goes on all the time. So interesting question is, the doctor left. For me, one of the interesting questions as a matter of technology is, at what point will we be able to improve science and technology to understand, to induce information in order to have the inability for people to lie? Now that runs up to another part of the Constitution because of the, you may not be able to take the fifth because you don't have to bring, evidence against yourself. But if you can do that, but we've monkeyed with that because I can still take your hair follicles and look at your DNA. I can take your blood samples, look at your blood. That still is not considered testimony against yourself. That's protected under our Constitution. So domestically, we've sort of fudged that line. But the next level of it said, if we can do that, that's where I think the science and technology community could be very helpful to be able to end the torture issue. Is, are there ways of inducing this issue? The famous line in which I think it was Mattis said, why don't we just give them a beer and smoke? And we said, well, sir, they're Muslims, they don't drink and they don't smoke. But nonetheless, it's a good attitude to take as a Marine. So the next issue became, at that level of debate, the next level is, well, as a matter of law or politically, it doesn't make sense to torture because it just ruins our reputation. And then the argument put forward is, but most of the adversaries that we fought over the last 20 or 30 years, they have used torture against our soldiers. So regardless of the fact that we will not do it, the history is adversaries will. You say that, yeah, but that's still, the golden rule. And then the third is, well, even if it does work, and even if our adversaries are going to do it, despite the fact that we're going to do, it's a question, as Elisa and Alberto said, it says more about us. But the question I always pose in these situations, why people think it's situational, why it continues, how many of you are parents? Your child is kidnapped, the classic example, right? And the kidnappers, this is the issue of the torture warrants that we talked about at one point under our legal system. They come to you and they say, we know the individual knows that where the child is, they put it in the classic coffin that only has X amount of air. Will you authorize us to do things that would be a violation of the law? How many parents would say, who raised your hands? Absolutely not. I would rather have my child die than the low probability that you can get information that may save the child. So I do this all the time in my law classes, and it's the range of answers are fascinating and what people really do when it's a gut question. As the Marines say, make it personal. And then the issue becomes, which the answer is, well, it can be done, but I want to make sure there are consequences to the decision. Regardless of whether it's successful or not, the individual performing, and some students say, I'll do it myself. Just tell me what I'm supposed to do. But I will then accept the consequences for having violated the law. And that to me encapsulates the dilemma of this issue of why it has continuity versus the golden rule. Under no circumstances will it be ever used. But the reality in the world that we live in, I think, is that different countries, different cultures have made different decisions about this. And until we can have a scientific, indisputable notion of that there's a better way of doing it that does not involve this type of physicality or mental cruelty, is why I think these conferences will continue to be held over and over again, because of what happens when it gets down to that basic human element of fear and the requirement to get the information to save someone who you think is a loved one. So I open that for the remarks. Thank you.
Thank you, Harvey. Well, let me start with a couple comments and then I'll go on some questions. Alberto mentioned these reports that had to be written over the weekend at no notice. Well, the team that did that was myself, Bob McFadden, our earlier panelist, and Mike Ellis, our former chief operational psychologist. So thanks for stealing a couple weekends away from me, Alberto, with those things. And Alyssa, your comments were kind of amazing to me, because the first thing I ever published was in the Huffington Post, based on Jose Rodriguez's book Hard Measures, based on the prompting of Human Rights First. And the title was "Torture is Illegal, Immoral, Ineffective, and Inconsistent with American Values." So that was the very first thing that I've ever published on the topic. Alberto, I'd like to talk to you about kind of the ethical dilemma that because I faced it, right? So I discover that the Department of Defense is going to systematically adopt a torture program. And I was an NCIS agent detailed to the Army, working for the Office of Secretary of Defense. And I ran it up my Army chain, and they said, we don't agree with it, but it's kind of approved. You're on record as of opposing it. And I didn't feel that was good enough. And I went to the chain at the Office of Secretary of Defense. And of course, I worked for Jim Haynes, who was part of the problem or program, and didn't go anywhere. And I was detailed away. So I went back to my parent organization, NCIS, Dave Brandt. And actually, I did it because I thought they were about to kill Muhammad al-Qahtani, prisoner 63 at Gitmo, with some of the things that they had already started doing on him prior to any approvals. And, I told Dave, we have to do something. It's not enough to be on record. We're federal agents, and they're on a naval installation, and people subject to the military code of military justice, uniform code, are about to engage in acts that I believe are international war crimes. And we went to you, Alberto, and I remember sitting in your office with the senior judge advocates of the Marine Corps and Navy, and how astounded and aghast you were when I explained the program to you. But you were the first official, other than my NCS chain, that didn't just nod and say it's okay, said, I have an obligation. And I remember your words to me. You said this could cost Bush the presidency, because you were appointed by President Bush at the time. So for you, I mean, what was like that? You were a senior position. The rumor was you were going from that job to either be the lawyer for the CIA or NSA. That was the rumor within NCIS. You were this rising star as this Republican appointee, and I got you a job at Walmart.
For me, it was always crystal clear. I was an attorney. Part of my job was to prevent and illegal activity and track it down and put an end to it. I mean, this is actually crystal clear. And then the prohibition against torture was the simplest kind of black letter law. I mean, this is categorical. I mean, it's like every law, domestic international treaties. In fact, the United States had represented such before UN Fora, that the United States categorically at all levels, anywhere in the world, forbids torture. And I was determined that I was going to protect everybody in my jurisdiction, my immediate jurisdiction was Navy Marine Corps. I was determined that nobody in the Navy Marine Corps would be put in legal peril by being involved in this kind of process. But then I had obligations as well, up the chain of command. Donald Rumsfeld was a client. Jim Haynes was a client. The president was a client. I was protecting all of them to ensure that this did not occur. So that was my thought. So for me, this was always very simple, not a question of a dilemma. And I was the right person to do it. People who are career civilian or military officers in the Department of Defense had children, mortgages, retirement, office at stake. I had none of that. I knew from the start that this is a job that would come to an end. And if anybody was going to take the risk on this kind of issue, that's why political appointees are designed and put in their jobs to tackle these kinds of riskier sorts of issues. But for me, I thought it was a mistake. As you know, Mark, I thought, gosh, people are overworked. Jim Haynes, for example, the individual, the lawyer, senior lawyer who presented this to Donald Rumsfeld, would fall asleep at the wheel driving home from the Pentagon on a couple of occasions because he's comes in and had a 2-foot stack of paper in the figurative inbox every day and was working around the clock, as most of us were during that period of time. I thought they just failed to spot the issue. Garden variety malpractice, and failed to exercise sufficient imagination to understand what these kind of vaguely worded enhanced interrogation or counter-resistance interrogation practices meant. So for me, it was very clear. But then I would sit in my office and think through, okay, I'm approaching this as a legal matter, but as a policy matter, would I use torture? I mean, and I would literally sit there and I would think, okay, maybe at 100,000 deaths, yeah, maybe I would use it. 10,000, 1,000, yes. 10, yes, maybe 1. And then it was very clear that once you start finding situational exceptions to the categorical prohibition, you could justify applying torture to save one person. And then why stop overseas? Why not apply the same kind of logic domestically as well? And it was clear to me that if nobody had the right, even terrorists didn't have the right to be free from torture, nobody did, because it would not be a legal right. It would be a situational policy question for any government, whether you would apply cruelty in any situation. And our calculus might be more restrictive, but the North Koreans might be different, or the Russians might be different, and so on and so on and so forth. And it led to a world in which rights were eroded. The constitutional framework, the values framework of our Constitution, our nation, would be fatally damaged if we were to inject the discretionary policy right to use cruelty within the government. And as a policy matter, this was disastrous. There was no European country that was going to amend their network of rights in order to follow the United States into the swamp of torture. So there was also that policy dilemma that actually proved to be even more consequential because the policy impact was enormous around the world within our network of allies and potential allies, and as a motivational force for foreign terrorists to enter the battlefield against us. So for me, this was always clear, but I was acting on imperfect knowledge. And as I got into it more deeply, I kept uncovering things over time. And for example, the fact that the White House was involved, DOJ was involved, CIA was involved, was a massive shock. I didn't at first suspect that it was there. But for me, my duty was always clear. As an attorney, as a citizen, as a member of the administration, as a colleague, I didn't have an option, nor was I looking for one.
Can I just add one thing to that, Mark? And that is, no matter how much Alberto tries to paint himself as ordinary and it really was quite extraordinary what you did. And I want to acknowledge that, because there's when the memo that you wrote was made public, and Jane Mayer in the New Yorker wrote a piece about it called The Memo, there were other lawyers who had a different vision of what their job was and who their clients were and what it meant to represent the United States, writing memos that twisted the law out of all recognition to give the client what he wanted, which was legal authorization and cover to do the unthinkable. And I remember when those memos were both made public, I took both of them and I emailed them to all my friends who were lawyers in government. and said, this is what it comes down to. What kind of government lawyer are you going to be? So individual character and, the law, again, the law is important. But what that experience taught me is that the lawyers and who they are and what their values are and their level of courage matters almost as much as the law. And I think that's important to say at a law school event.
Thank you. So to me, I agree everything you said. To me, the failure is, it's a failure of not having an institutional ethic. That's the problematic. It should not turn on an individual brave lawyer who sees it. It's a failure of the system. And unless you have that clearly drummed into the attorneys as an institution, as a corporate group, because we often said in certain, I'll give you examples of, do you think there are circumstances in which you'd want to wire up a Catholic confessional? So I assure you in my career, the answer is yes. There were circumstances in which we thought it would be very effective. But the institutional attorneys were, no, we believe in that privilege. That's fundamental privilege. You can't, we're not going to do it. We're not going to go to the judge and make the argument. It stops because of the corporate view of what the legal community understands is the left and right margin. So that's one issue. The second issue, I still always distinguish between domestic and international because, so we start the idea of treating prisoners of war humanely. It starts with the American Civil War and Lincoln's Order 100. Because prior to that, in the ancient form of war is you killed your prisoners. And then you took the women and you made them citizens of as a conqueror. That was the logic of war. And we stopped that. And one of the reasons it stopped, because Lincoln's position is, the goal is to incorporate the South back to the Union. If we do not treat the prisoners of war who were captured from the South, and we treat them cruelly and inhumanely, we're not going to be able to, at the end of the war, bring the South back into the Union. That's the origin of this concept. And that is also internationally, if you know, if you're captured, you're going to be tortured or killed, why give up? It's actually a self-interested argument for when you're in the profession of arms. Because and you tell Americans, they're not going to, if you give up your arms, they're not going to treat you under the Geneva Conventions. You go, well, I'm never, what's the point of giving me up? Because the point is you want them to join the board and then come back into the system. So these are the two issues that these events have demonstrated. The lack of institutional ethics drawn into our group, and B, the lack of understanding that this is a self-interested argument. It is not a moral high ground argument, which is why we should be even more emphatic of why we want this to be drummed into the institutional decision making. Over.
The Bush administration treated this always as a legal issue. Can we do it? Consequently, they kicked us over to the DOJ, which then prepared a series of bad faith memos that were just parodies of what the legal obligation, legal craft is all about. But it never asked the question, should we apply torture? So as you kind of dig through the records of the Bush administration, you try to find, okay, what was the NSC's then approach to this? And Condoleezza Rice never asked a junior staffer to take a weekend, as we did with NCIS, and prepare a memo as to whether we should engage in this kind of practice. So that was never done, even years down the road, after it was clear internally that this was a torture program. It was contrary to our values, our international order, and we were paying an enormous price internationally for this. That question was never asked. And you got to wonder, I mean, the issue was raised, by the way, even though there was no memo about the should, The authorization, request for authorization to continue the enhanced, to start and then continue the enhanced interrogation program was taken to the full NSC 3 times, unanimous approval. I spoke to Colin Powell about this, a moral giant, and he regrets that he didn't stand up to this, but we talk about institutional failure, institutional ethic, the failure of the NSC as well. And not only at the heat of the moment, the fear and fury of 9/11, but then 4, 5, 6 years down the road, the inability to take a clear look at this and then draw the conclusions, correct course, is to me one of the continuing shocking elements about our behavior on this issue.
And Harvey, you and I have had these discussions quite a bit, working together with Alberto and others on the Cyril Gitmo Working Group report. And we kind of talked about, I'd like you to kind of expand upon it a little bit, is, there's some resistance, particularly when you start using the T word, right? The torture and abusive, interrogations, and whether I call it a family of interrogation abuse. And I remember Alberto, when I first talked to him and said, well, I don't know if it meets the legal definition of torture or not, Alberto. He said, it doesn't matter. It's cruelty. The bar, it's cruel. It's the 8th Amendment. That's the first thing Alberto said is don't get clouded up in this torture thing. It's cruel punishment, and we cannot do that institutionally. But what does it say? And I think this is kind of the challenge that we faced, even getting our working group report out with the verbiage of those senior lawyers who, some of those who I may have gone to, who just looked the other way.
Yes. So the backstory of part of the issue of the report was there was a lot of debate about the term enhanced interrogation techniques versus torture. And my personal convictions, and as you can imagine, many of us know almost all the senior attorneys that were involved in all those processes. And those who participated in decision-making and those who were present but not directly involved but knew of the issue. So it becomes quite a gut check, because it's an old phrase that I grew up with, are you part of the problem or part of the solution? So if you as an attorney didn't say anything, or you turned your head away, or you argued, well, there seems to be a legal memorandum arguing that it's not a violation of the Torture and Cruel and Inhuman Grading Convention, you have to look at yourself and sort of think, like, why didn't I resign or say something? So that word became quite controversial for most of the attorneys who were new of it or were aware. And I think the term is why they look at themselves and say, well, obviously I'm not someone who supports torture, but enhanced interrogation technique that doesn't have the intent and has some legal wiggle room to remove the understanding became very, very difficult board, given the political breadth of the people who signed the report. But that's my sense of why there was such, and then the second issue is, so, and I've been involved in some of this, representing some of the people, which is that you've had like 7 or 8 investigations. Think about that. 7 or 8 investigations of this process. We have no one who is held accountable above an 06 or 07 level, and very few at that rank. And that's why I started with knew or should have known of things that were taking place. So this is a very hard moment for the Pentagon, very hard moment for the policymakers. And the idea, if you don't hold people accountable for these decisions, and it doesn't hurt your career. So even the way Alberto started, he was the perfect position because he could make the decision and it wouldn't have an adverse effect on his career, because he was going to have to leave anyways because he was a political appointee. The calculations that are going on So at the War College, as a dean, I used to say that we have one of the most fascinating general officer corps in the world. It's a general officer corps, which is one of the bravest officer corps, personal brave, that we have in the modern world. But they would rather take a bullet than tell their superior officer they're wrong because of the potential consequences on their career. The idea of having a direct confrontation with your superior officer, there's someone from the military I can see, who it's anathema. The gesture that we use always is this. So for civilians, that means, you see my rank? I'm a 4-star, I'm a 3-star, you're like a 2-star. The conversation is ended because I outrank you. And end of it. And if you continue, you know I'm gonna be sitting on your promotion boards. And if you continue like this, I'll kill your career. And I have the power to do that because I sit on the promotion boards. So that issue is also at the core of why there was a sense of an inability to say, stand up and say, this is just. And then the third issue I would say is, I used to run a course, when should a military officer resign? When's the last time you can think of a senior civilian inside our enterprise that resigned because they disliked the policy decision? And the more famous one was, remember, with our friend Jimmy Carter when he decided to have the attack in Iran, and his Secretary of State said, "That's the craziest idea I've heard. Stop." And our advisor Brzezinski came with Carter alone, flipped the decision. Secretary of State comes back and goes like, "I can't believe you're doing this." He said, "Well, I spoke to this Reagan. I was going to do this." He goes, "I had an opportunity." And then the gentleman, Secretary of State, said to Carter, "Whether we are successful or not," which we were not, "I'm resigning because it's clear you've lost confidence in me. I'm supposed to be the Secretary of State advising on these matters. You've lost." So he resigned on a matter of principle. We have not had serious military officers resign as a matter of principle. And to me, that's a complicated issue about the culture that we're creating.
So let me shift focus a little bit, Harvey, here, and for all the panelists, to what we now know about effective interviewing, what we now know about false confessions, what we know about these wrongful convictions that we've had based on this pseudoscience or lack of science. And police officers, investigators, rightly so, take a lot of the blame. But what about the criminal justice process? What about those prosecutors who are accepting these cases? What about those lawyers who are just rubber stamping this? At what point does it become who knew or should have known these things, and these cases are stopped before they're moved forward through this criminal justice process?
So because of my career, I've been involved in so many controversies. It's complicated, but for those of you who remember the Mr. Whitehurst, and the FBI laboratory, in which the argument was that it was cops in lab coats who were doing the testimony and the issues of DNA. And I was part of the task force that had to figure out what to do with those cases. And what did it mean to agents who were testifying clearly without appropriate background? And that controversy ended resolved, and the Bureau, it's the largest forensic laboratory in the world. We do 50,000 criminal cases a year. Basically, the criminal system will not work unless you have trust in the FBI laboratory. And we had never had a PhD scientist running the laboratory before the scandal hit. It always had to be an agent. Mr. Hoover, the joke of the Bureau was, as you know, they go to Hoover and say, we have to do brain surgery. And Hoover goes, "Well, who's the agent?" And they go, "Well, no, we need a doctor." No, I want an agent to go to medical school, then he can come and do it. That culture had to be crushed. And that issue of, are you participating in a criminal drug where you know that you're tinkering with the evidence? Our whole system will crumble. It also turns on, as a law clerk, do you believe the police or not? My federal judge was like, "Well, the police officer testified under oath. And I was like, well, we had to say, like, Judge, they lie. He was like, what are you talking about? He was old school, right? So it's like, they lie. It's the blue line. And it was like, I don't know what you kids are talking about. You just don't understand how the system works. Until we started getting evidence of this happens. And his world was rocked. He was in his 70s, classic American story, and he just was rocked that you're trying to tell me this. And I said, yes. And the other problem is, what's the consequence? What are the appropriate consequences when people who are sworn to uphold the law violate it, hedge it? In the world I came from, it was like they should be really, really prosecuted. Dismissal is necessary, but not sufficient. And until you get that institutional court and they understand, wow, I have just crossed the line, we're going to continue to have this level of complexity.
I'm going to want to open up to the audience for questions, but I do want to make sure that we highlight one additional point, because I think it's critically important in our attempts to roll out the principles of effective interviewing, the Mendez principles. We've gone to different bodies asking for endorsements and for support. And while I've not heard any public proclamation of this, Juan and I went to Alberto and asked him if we could try to elicit endorsement and support from the American Bar Association. And was delighted to learn some good news recently. Alberto, you want to just kind of address that? Well, the week after I retired, to my regret, the ABA House of Delegates unanimously approved and endorsed the Mendez principles. So I think that'll start another avenue for publicizing the importance of this within the American legal community at all levels. So that's good news. Yeah. So it's nice that the ABA has endorsed these principles here, and hopefully more law enforcement organizations will, and we'll see a cascading effect on down from that. But thanks for helping coordinate that, Alberto. Yes, go ahead.
My name's Marion Messing. I'm a captain in the U.S. Army Reserve. I'm currently mobilized onto active duty. I'm one of the military counsel detailed to defend Walid bin Attash. He's one of the accused in the 9/11 case in the military commissions. It's the sorts of issues that the panel has been talking about that originally sparked my interest in human rights and becoming a lawyer and also a judge advocate. And I remember being in high school and reading the New Yorker article about Mr. Mora, and found it very inspiring. I want to go back to something that Mr. Rishikoff touched on, which was prosecutions for people who engaged in torture and authorized it, knew it was going on. One of the things that never ceases to astound me is that so many of the key players went on to bigger and better things. Gina Haspel became CIA director. Now she has a sinecure at King and Spalding. David Addington went to the Heritage Foundation. Now he's at the National Federation for Independent Businesses. John Yoo is a tenured professor at Berkeley. And so I'm, if you could go back to early 2009, when Obama is inaugurated, what would you say to Obama to convince him to prosecute these officials? And what would you say to the American public to convince the public that this isn't, as Obama put it, a partisan witch hunt? Because it's only a witch hunt if there aren't actually witches. But these witches bragged about it. Bush said, I order torture, damn straight I did. So how would you convince both the Obama administration to have, prosecuted and held accountable these people who, authorized and engaged in these heinous things? And how would you explain it to the American public? And just a last note there, it wasn't until 2014 that the New York Times even started using the word torture to describe the enhanced interrogation techniques. And so it, if we don't want this to happen again, I think we have to, figure out how to actually hold people accountable and explain to the public why that's important.
Well, I don't think Alberto's that old. How young were you when you actually wrote that? So my issue on that is nuance. The first is that what Alberto was alluding to was very smart lawyers can look at documents and give interpretations of the document. And they will argue that it's, quote, lawful. And as Alberto said, it may be awful, but their interpretation is lawful. So as you know, DOJ did an investigation on John Yu's memos as to whether or not there should have been a disbarment, whether or not there should have been some level of penalty imposed on it. It was done by one of the classic prosecutors of DOJ, a guy named Margulies, who literally served the DOJ for 50 years and was involved in almost every complex issue that I can remember from the last 30 years in the DOJ got involved. And his conclusion was, you made the interpretation. The interpretation, as far as he was concerned, was incorrect, but it was a colorable claim under the law, which we were all taught in law school as a color. And therefore, he recommended to Eric not to pursue any issues. So my issue there is, once John Yu made the interpretation, which, we've had lots of lawyers and even lawyers who do all sorts of interesting analysis of statute. There was not an institutional vetting of the analysis. So there's something called, the list, the big list. If it's a special access program, there's a digit list that only certain people are allowed to look at the document in order to keep it classified and secret. And I know John Yu, and I said, John, I know you have a high opinion of the legal analysis, like all Supreme Court law clerks do, and that you knew you were not an expert in international law. You also knew you were not an expert in medical law. Why did you not take this document and walk it over to what we call L, the senior attorney at state, whose job is to interpret international law and international treaties? And the answer was he wasn't on the digit list. I said, well, really? He said, well, what would you do? I said, being me, when I said, I might have walked over there with the document, said to L, I'm going for lunch downstairs in the cafeteria. There's a document here I'm leaving on the desk. You're not on the list, but it might make for interesting reading, but you might be breaking the law. And brought him into the process. So because you want an institutional understanding of that interpretation. So that's for the lawyers. Now for the policymakers are saying, which you could say to the policymakers, what you're trying to do is a violation of the law of armed conflict. It also may be a violation of domestic laws. But don't forget, we have something called covert action. And covert action, when it's applied internationally, very often we are breaking our domestic laws, but we are performing them under the color of sovereignty. So your issue is, what should we do to stop, to make it clear, but what is the appropriate penalty for the policymakers who decide to go down that path? And as you know, it helps explain how divided our country is. And in that period of time of the fear that was overwhelming the country, that's helped explain why they went down that path. But as you said, there's been no public airing of what the appropriate issue is in response. So many of those individuals have gone on to careers because of the issue of how certain segments of the American people still say, as Alberto said, you're now at Rhodes Scholars, potential Rhodes Scholars. We used to say Rhodes Scholars, the best part of their career is behind them, but that they, as a moral issue, don't see a problem given the circumstances of what the evaluation is. It's not categorical. And that's what makes this such a difficult issue for us to deal with. It. But looking at it, I think is what is required. And have other people understand what is the potential consequences. But we have, the country today is so divided that there are people who still believe that was the right decision to go down.
Alberto, we're going to let you close it out.
Well, no, I'd like.
Yeah.
We say, I've got a couple of things to say, but I'd like Elisa to close it out because she raised the issue about the Obama administration. And there was a huge fight with the Obama administration concerning the issuance of the torture report, as well as the issue of accountability. And Elisa was at the very heart of that very close run battle. I mean, the torture report was almost not issued. And if Obama had his way and his team had his way, it would not have been issued. So that's the story to be told. But let me, two anecdotes. John Yoo. I met with John Yoo at the Pentagon after he issued we received his legal memo concerning providing guidance, OLC guidance to us. And I wasn't buying it. It was a piece of crap. I mean, and it was dangerous, not only because of its definition of torture, but even more dangerously because it was a two-part memo. You may recall, it had the torture part one, and then part two was commander-in-chief authorities. And fundamentally, John Yoo's view was that it doesn't matter what the law said on torture because the president's commander-in-chief authority trumped everything, and the president had the ability to order torture. In fact, I challenged you on this. I said, look, John, what are you saying? That the president can order torture? And John said, yes. And then I started saying, I don't, and he said, he put up his hand like that and said, stop. I know what you're going to say, but you and I are lawyers in this administration, and our job as lawyers is to tell our clients what the law is, as I have told you what the law is here. Now, you were about to make a statement of policy, and maybe the policy you're about to articulate would be the better policy, but that's not our job. Our job is to talk about the law. And it was like just so outrageous. It was just such an outrageous set of comments and so false. And then he walked out. I mean, he was just, we didn't even sit down. He exuded the notion that he was wasting his time in talking to me, and certainly felt that way after we had that discussion on the torture issue. But one comment about State L. I mean, on my last day at the Pentagon, and Will Taft has been a friend for many, many years. State Will was the legal advisor to Colin Powell. And he came back and we were just kind of reliving the war on terror. And we were eating at the Navy Secretary's mess. And he said, we were cut out. He said, Rumsfeld went to the president. He says, look, I'm happy to, because there have been clashes between Rumsfeld and Powell concerning the various aspects of the Iraqi war, Afghan war, war on terror, military commissions, and the rest of that. And Rumsfeld went to the president and said, look, it'd be a hard job, but I'm happy to take on the burden of coordinating administration policy. And Bush told him, you got it. And Rumsfeld went back. And from that moment on, the State Department was cut out of all paperwork dealing with certainly the legal issues on the war on terror. So here's Will Taft, former ambassador to NATO, former deputy secretary of defense, I think secretary of the army. I mean, just one of the most glittering, accomplished resumes with the character of Richardson, Elliot Richardson. I mean, just an individual who just exuded all the principles that a lawyer should be exemplifying. We didn't get a comment. And actually, his deputy, who was in charge of coordinating all the war on terror matters, couldn't understand how come they weren't winning the arguments in the administration with Office of Legal Counsel and NSC and so forth. They kept losing arguments and they weren't getting real answers. It didn't make any sense. And then it dawned on him when he saw some of these decisions made concerning military commissions and then enhanced interrogation. He only saw part of the enhanced interrogation picture. But he says, it dawned on me as I was reading a presidential memorandum, which was signed by Bush personally, that presidents never signed these kinds of documents. They're generally pushed down at lower levels, but now the president was signing this on a legal issue. Is what I had in my hands was evidence of mens rea. The administration was committing a series of crimes, and he started, contrary to security regulations, maintaining a file on these decisions that he couldn't understand, but he knew he was going to have to present them at subcommittee. He presented them, or somebody presented them, to the Senate Judiciary Committee when Jim Haynes's nomination for the, I think for the Eighth Circuit or one of the circuits came up, and miraculously appeared under the Democratic staff's chambers, and that derailed Haynes's record. But it's an example of how individuals and then institutional failures and then gamesmanship to accomplish a certain objective, in this case, a legal objective, was engaged in. But over to
just quickly, because I know that we're out of time, but that's such an important question, and it's one that we grappled with. This question of accountability. It's one of the reasons that I have all of my law students read George Orwell's Politics in the English Language. If you don't know it, you should read it. Whenever you start to find yourself writing like the writing that he enhanced interrogation and all of that, then you know that you're probably in trouble. But they're having worked on accountability in other countries for horrible human rights violations. A few things I know. One is, you spelled it out at looking at what these folks went on to do. On the one end of it is criminal prosecutions. Torture is a crime under the US code, actually punishable by death, sadly, if the person dies. It's quite clear what the law is. But on the other end, there's a whole spectrum of what constitutes accountability. There are truth commissions. There is, an accounting of an official record of what actually happened. There's lustration, which we saw a lot when in the former Soviet, when the Soviet Union dissolved, of keeping people who did these things at least ending their careers in public service. All kinds of things. And many of us have been working on the whole range of those issues with an idea, knowing what you said is true, that without accountability, we're destined to repeat. It doesn't matter how, we want to embed these values in our institutions, in our systems. We have to be able to demonstrate that there's a cost to thinking outside of that box and acting outside of that box. So we really pushed with the Obama administration, who was very hesitant to do anything that looked political. Because in fact, the witches were mostly of one political persuasion. So he didn't want to do that. So we worked really hard with the then White House counsel, Greg Craig, to try to push forward the idea of some kind of truth commission, at least something that would, because people were still saying it didn't really happen, or it wasn't really torture, or all that. We were fighting a war about the facts and getting them on the record. That was really difficult. And he ended up getting fired. That's not the only reason, but he was convinced that we needed to do something like that in order to, fulfill Obama's commitments on torture. That's when we shifted to making sure that the Senate Select Intelligence Committee report on the program was finished and was declassified, which still hasn't happened for the complete report. There's a lot of unfinished business. The other thing I know from working on accountability for human rights violations in other countries is that the arc can be very long. And I would not give up on the idea of holding people even criminally accountable for some of these horrific crimes that hurt our country so much down the road, because there's people with long memories and lots of written record, as Alberto said.
Well, please join me in thanking our panelists.